It's 2025, and no matter which side of the debate you're on, pro-gun or pro-regulation, nearly everyone claims to understand the Second Amendment. But what if the widely accepted stories are oversimplified, or worse, misleading? In this video, we'll reveal the truth about the Second Amendment that people rarely talk about, how it evolved, why its meaning is still contested, and what really lies behind the modern debates. Stay with me, because what you think you know might change by the end. 1. Origins. English and colonial roots. To understand the Second Amendment, you have to go back before the United States existed, to England. In 1689, the English Bill of Rights was adopted after the Glorious Revolution. That document granted Protestants the right to have arms for their defense, as allowed by law. It wasn't absolute, it was conditional and limited. American colonists, especially in the 17th and 18th centuries, deeply internalized the idea that bearing arms was a safeguard against tyranny. They had lived under monarchs who sometimes tried to disarm rebellious or religious minorities. Legal thinkers, especially William Blackstone, wrote about a natural right of resistance and self-preservation, that when governance fails, people retain a right to defend life and property. This English tradition fed directly into colonial charters and state declarations of rights. For example, Virginia's Declaration of Rights in 1776 recognized a right to bear arms for defense. So when we talk about the Second Amendment, it didn't emerge in vacuum. It came from centuries of constitutional and political struggle over power, liberty, and the role of arms in society. 2. Framing the Second Amendment, 1787-1791. After the Revolutionary War, the founding generation understood the dangers of standing armies and centralized power. The Articles of Confederation had weaknesses: no robust national military, no power over state militias, etc. The Constitution, 1787, sought to create a stronger federal government, but many feared it would become tyrannical. To win ratification, the Bill of Rights was promised. Among the amendments proposed was one to protect the right to keep and bear arms. James Madison played a central role. The original draft version in early Congress was, "The right of the people to keep and bear arms shall not be infringed. A well-armed and well-regulated militia being the best security of a free country." The version eventually passed reversed the order of the clauses. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Important things to note during the debates. The phrase well-regulated in the 18th century meant disciplined, well-ordered, properly functioning, not necessarily rigid regulation or control in the modern sense. Militia was understood by many framers as an armed citizenry, not a separate standing force, the idea being that ordinary people could be called to defend the state. The prefatory clause, a well-regulated militia, states a purpose, but in modern interpretation, many lawyers and judges argue it does not strictly limit the operative clause about the right. Some framers worried about religious objection to bearing arms, the idea that some people were conscripted into militias despite religious scruples, though ultimately that clause was dropped in the finalized amendment. Thus, from its birth, the Second Amendment had dual-purpose language, referencing both a collective militia and an individual right, dimension which has fostered ambiguity for centuries. 3. Early interpretations and legal ambiguities, 19th, early 20th centuries. For more than a century, the Second Amendment was seldom litigated. It was often seen as a relic, something reserved for discussion in philosophy and politics, not daily courts. During the 19th century, most legal scholars viewed the Second Amendment through the lens of states' rights and militia concerns, rather than individual gun ownership. In Nunn v. Georgia, 1846, a Georgia law banning the sale and carry of pistols was struck down by the Georgia Supreme Court, which held it violated the Second Amendment. This was one of the earliest state court cases to interpret the amendment with individual implications, but federal courts were reluctant to intervene. America's judiciary generally left firearms regulation to states and local governments. Moving into the 20th century, as the federal government began to expand prohibition, crime, regulation, etc., debates over how much federal power could restrict arms began to intensify, but the Supreme Court largely avoided ruling directly on the breadth of the Second Amendment. 4. Key turning points. Miller, Presser, and Presser's legacy. Some landmark cases set the stage for the modern debate. United States v. Miller, 1939, is often cited. The Supreme Court upheld a conviction under the National Firearms Act for a sawed-off shotgun, reasoning that the weapon in question did not have a clear relation to a militia. It avoided a sweeping statement on individual rights, but implied that arms must relate to militia utility to be protected. Presser v. Illinois, 1886, held that states cannot prohibit the formation of citizen militias, but also that the Second Amendment does not inherently restrict state-level control over firearms beyond that. These decisions produced ambiguity. Was the right primarily about a collective state defense role, or did it protect an individual's ability to possess arms for self-defense? This ambiguity persisted until the 21st century. 5 D.C. gun laws and the Heller case. Here's where things get real and controversial. The Firearms Control Regulations Act of 1975 in Washington, D.C. banned virtually all handguns, prohibited acquisition, and forced residents to keep firearms disassembled or locked. In 2003, Dick Anthony Heller, a special police officer, challenged this law, claiming it violated his rights. His request to register a handgun was denied. The case eventually made its way to the Supreme Court as District of Columbia v. Heller. In a 5-4 decision in 2008, the court held: 1. The Second Amendment protects an individual right to keep and bear arms, unconnected to service in a militia. 2. The D.C. ban on handguns and requirement that firearms be kept non-functional, even for self-defense in the home, violated that right. 3. The prefatory clause about militias is not a limiting clause. It helps explain the amendment's rationale, but does not narrow the operative clause. Significantly, the majority opinion, authored by Justice Scalia, emphasized that self-defense in the home is the central component of the Second Amendment. Thus, Heller was the first major Supreme Court ruling in decades to define the scope of the Second Amendment in modern times. 6. McDonald and Incorporation to the states. Heller answered the question for federal jurisdictions like D.C., but what about state and local gun laws? In McDonald v. City of Chicago, 2010, the Supreme Court held that the Second Amendment applies to the states. Through the 14th Amendment's Due Process Clause, Incorporation doctrine, that meant states and cities could no longer enact total bans on handguns in the home without violating constitutional protections. But McDonald left many other issues unresolved, such as whether public carry, types of weapons, or background checks are consistent with the Second Amendment. 7. Post-Heller. What regulations are permissible? Even after Heller and McDonald, the court made clear that the Second Amendment is not unlimited. Some regulations remain constitutionally permissible. The majority in Heller acknowledged that certain long-standing prohibitions, for example on felons' possession, prohibition of dangerous and unusual weapons, could be upheld. Lower courts now apply a mix of text, historical tradition, tests, or tiered scrutiny to evaluate whether a law is consistent with history and precedent. Examples of contested regulations include assault weapons bans, magazine capacity limits, waiting periods and background checks, public carry, concealed carry laws, age restrictions. Recent rulings have challenged laws barring 18 to 20-year-olds from buying handguns. Some courts now demand that modern regulation align with historical analogs, meaning legislators must point to similar regulation in the 18th or early 19th century to justify contemporary laws. This criterion was emphasized in New York State Rifle and Pistol Action v. Brune 2022. Not deeply covered in earlier parts of this script, but relevant to current debates. The practical result: many gray areas remain. Courts disagree, state laws vary dramatically, and the balance between rights and regulation is still in flux. 8. Critiques, controversies, and counterarguments. 8. Critiques, controversies, and counterarguments. To present a balanced view, we must grapple with criticisms and counterarguments that people often overlook. Historical critiques argue that Heller misreads historical sources. Some scholars say Scalia cherry-picked evidence and downplayed countervailing views from the founders and early republic. Some argue the framers never intended the Second Amendment to be a personal guarantee, but rather a collective safeguard tied to state militias. Others note that even in the 19th century, courts generally deferred to states for firearms regulation, suggesting a practical, not absolute, right. On the safety front, critics argue that modern weapons are far more lethal than anything the framers anticipated. Therefore, originalist reasoning must adapt to modern technological realities. Some gun control advocates worry that emphasizing individual rights without robust regulatory guardrails can lead to more violence, accidents, or social harm. A final critique: many people treat the Second Amendment as untouchable scripture, rather than a living, contested, constitutional provision. 9. The forgotten truths, what people rarely know. Here's where we land. The truths many people don't realize or choose to ignore. 1. Ambiguity was built in. The framers wrote intentionally broad and dual-purpose language. The tension between militia and individual rights was never fully resolved then, and it remains unresolved now. 2. The individual rights interpretation is relatively new. For much of U.S. history, the Second Amendment was not enforced as a broad personal right. The Supreme Court only definitively recognized that view in Heller in 2008, more than 200 years after ratification. 3. Not all arms are protected. Even in Heller, the court said dangerous and unusual weapons may be regulated or banned. The amendment is not a blank check for any weapon. 4. Regulation is still constitutional within limits. The court's decisions leave room for regulation on matters like background checks, safe storage laws, limits on certain classes of people, etc. The challenge is whether those laws follow historical precedent. 5. Historical analogs matter now, because modern courts often require that regulation align with historical precedent. Gun laws passed without historical roots are more vulnerable to being struck down. 6. State versus federal tension persists. Even after incorporation, states still exercise wide discretion over firearms law. Differences between states, some very permissive, some very restrictive, show how contested the balance remains. 7. Technology outpaces original law. The framers could not have anticipated semi-automatic rifles, GPS tracking, biometric safeties, or mass shootings. Any legal interpretation must grapple with the gap between 18th century arms and 21st century technology. 8. The debate is partly symbolic. Many people speak of the Second Amendment as if it's a sacred creed, when really, it's a constitutional provision whose meaning is developed through argument, litigation, and democratic choice. 10. Conclusion and call to action. Reflection. We've traveled from 17th century England through the founding era into modern Supreme Court drama and arrived at a simple but profound insight. The Second Amendment is not a monolith. It is a living, contested frontier of constitutional meaning, shaped by history, law, technology, and conflict. So here's what I want you to do next. Dive deeper. Read primary documents, the Federalist Papers, early congressional debates. Engage critically. Don't accept simplistic slogans or memes. Talk civically, whether you lean pro-gun or pro-regulation. Understanding the complexities helps you argue better. Subscribe, follow for more deep dives into rights, law, and constitutional truths. If you found this illuminating, share it with someone who repeats they keep trying to take our guns, because the truth is more complicated and more powerful than slogans. Let's know our rights, because a well-informed public is the best guard against tyranny, extremes, and misinformation.